Hello everybody, I'm George from Ireland, so welcome back to my English law channel, and I'm going to be talking about the Law of Property Act 1925. So this was really a sea change in the system of property law. So there were major reforms. The idea was to make the whole system simpler, to make it a bit more rational. Real and personal property law were both affected. We're obviously looking more at real property as in land, and it reduced the number of tenures to a single form. Anyway, it was meant to make conveyancing easier. So there are lots of different types of rights which can bind land, third-party rights, for instance, and that makes dealing with land a lot trickier than dealing with any other kind of property. And so in land law, we want to find a via media between the interests of the third parties and those who are buying the land. So you'll see that people in land law, they use a number of different phrases to describe this balance which has got to be struck. Anyway, so what else was I going to say? So it was after the First World War, a lot of land changed hands. People killed in the First World War, death duties, sort of inheritance tax. Some families couldn't afford to pay that, selling off the land. So to sort this out, because the system was just deluged with land changing hands. Anyway, so the 1925 reforms, they make life easier. The purchaser, they make this conveyancing more straightforward, and they obviate the previous necessity for a purchaser to make extensive inquiries before buying land. So we're going to look at unregistered titles and then later registered titles. Probably won't come around to registered titles today. So anyway, registered titles matter far more because there are far more of them. About 90% of the land in England and Wales is registered. So these two systems exist. They're quite different. Registered land is about having a a total system. An exhaustive system covering all the possible land, compendious, that's it, system. Okay, but in unregistered land, as in registered land, I think there are rights which are overreachable. Some of these rights can be got rid of by the buyer. Anyway, but they might be overreachable in one system, but not in the other, depending on the nature of the right and whether it's registered and so on. In registerable land, you can protect your rights by putting on the register. Anyway. So the reason here, the reasons that both systems exist, is trying to make life easier for the purchaser, so he doesn't have to make so many onerous inquiries and go around and look at the land himself. Okay, there are some obligations which behove him to look into land like that, but it's not as burdensome as it used to be. Okay, so we don't have as many estates, illegal estates, as we used to, as in kinds of ownership. So the 1925 system, it radically reduced the number of estates and the third-party rights which existed under law, and the sort of interests which would automatically be binding upon a purchaser. So if you look at Section 1.1 of the Law of Property Act 1925, you'll show that there are only two estates which now subsist at law. These are fee simple absolute in possession. That means the whole of such an estate is the owner of the land. And the second one is term of years absolute, which is a lease. So these are the only interests that you can find, legal interests you can find in the Law of Property Act. They're right there in Section 1.1. Now there are other things. Easement, for example, right of way or right to light exists. A charge by way of a legal mortgage is another one. And there are other estates and interests which take effect in equity. So those equitable interests, you'll find them in Section 1.3 of the Law of Property Act 1925, LPA for short, I'll call it. So these are a bit different to freehold estate. And fee simple absolute possession is of course equitable, but that's an unusual one. So if land is given to Arabella for life and the remainder to Belinda fee simple, both Arabella's life estate and Belinda's remainder interest are equitable, as they're both estates which are not listed under Section 1.1 of the LPA, and they're not therefore capable of being legal. Okay, so you can create successive interest through a trust. I'll come on to that in another video. The trustee would hold legal estate, and then Arabella and Belinda would, one after the other, have it the beneficial interest. So a fee simple owner is someone who's granted a lease and is still technically in possession, because possession, that includes receiving rents and profits or having the right to receive them even if you don't actually receive them. That's as per section 205.1 of the LPA 1925. Therefore, the landlord could hold legal estate in land even though somebody else exclusively possesses the land by a lease. So we must realise that section 1.1 and 2 of the LPA 1925 simply say what interests can exist at law. As I said earlier, a legal estate or interest is necessary to make sure that the estate or interest is created or transferred using the proper formalities, and if you don't, it may very well not be transferred. For instance, in most cases you need a deed, which is a particular document. If you're going to convey land or create a legal estate, that's as per section 52 of the LPA 1925. Okay, this is a new deed is needed to effect a transfer between a vendor and a buyer, and that's not simply handing over the extant deeds. Those deeds could prove root of title, but this is not what you need to convey the land. So if a deed is not used in creating or transferring an estate or interest, then the person who's supposed to receive it will not receive the legal estate or interest, because anyway, why, if anything, what if anything will this person receive? So in land law, there's something which is specifically enforceable, and that's a contract to transfer a legal estate. And that must be a contract which is consonant with Section 2 of the Law of Property Miscellaneous Provisions Act 1989. So an equitable version of an estate or interest will vest in land, and the intended recipient will receive that. Remember, the old equitable maximum equity regards as being done what ought to be done. So from then on, the transferor, the one who's transferring it, handing it over, holds a legal estate interest on a constructed trust for the transferee, as in the intended recipient, and the intended recipient will have the equitable title because the legal conveyance wasn't done the right way. So let's look at more of the unregistered title system. The 1925 reforms were extended by the Law of Property Land Registration Act 2002. Anyway, I'll come to that more in greater detail. So looking at unregistered title. So how come there are two systems? It's mind-boggling. So the purpose of the Land Registration Acts 1925 and 2002 was to make the whole conveyancing thing more straightforward, registering all titles, having them all in one register. And the Land Registration Act 2002 obliges people to register land whenever it's transferred or subjected to a first legal mortgage. So why do we have to have unregistered title? Well, because in case you get a case with it, you wouldn't be able to cope if you didn't know. So the 1925 system, we know, was supposed to be for a short term, and everything's going to be registered quite quickly. But anyway, I think I've done this before, so I'll look on to overreaching in unregistered title. So the 1925 laws said that a purchaser would be bound by legal interests even if he did not know about them. Remember the old legal maxim, legal rights bind the world. They're binding on everyone, including those who don't know about them. Equitable rights are either overreachable or registerable as land charges. So overreaching means where the purchase of legal estate takes it without being bound by any extant equitable rights in land. But the equitable rights don't simply disappear, instead they turn into a share of the purchase money. So overreachable rights are usually familial in character, for instance, interests behind a trust, or registrable rights of those which are business ones, to do with easements, covenants, and options. So the interests can be registered as land charges under the Land Charges Act 1972, and so those can't be overreached if indeed they're registered as land charges. So people often find this very difficult to conceptualise. How come some equitable interests are overreachable and other ones are registrable? Well, that's because an equitable interest is protected. So in trust, we think that the trustees are there to manage the assets that they're holding on trust, and that means they have the power to buy and sell property belonging to the trust. So it's vital for the beneficiary and the buyer that when a trust asset, for instance land, is sold, the beneficiary's interests move from the asset to the proceeds of sale, i.e. the money. Otherwise the trustee would never be able to sell any trust property, and that's often the right thing to do, is to sell it. And by contrast, if we're looking at non-trust equitable interests, the holding interest needs the interest to continue being binding over that land, even after the land is sold. So that's the key distinction there. Okay, So go on to what Lord Justice Robert Walker said in Birmingham Midlands Mortgage Services Limited and Sabawal 2000. The essential distinctions between commercial and family interests. Commercial interest cannot sensibly shift from the land affected the proceeds of sale. A family interest can do, since the proceeds of sale it can be used to acquire another home. Close quotation. So overreaching is blatantly applicable to beneficial interests, and after Sabawal, it appears family interests created by propriety or estoppel are therefore comparable to a beneficial interest. Anyway, it's dubious, though, whether we can extend overreaching, applying to right, when it's an unconscionable transaction. These can be set aside. Mortgage Express against Lambert 2016 being a case in point. Okay, that's enough for the moment. Goodbye.